issues are of primary concern facing courts today. Courts really have to learn how to fairly and swiftly deliver justice in the face of diminishing resources. And so the Supreme Court must systematically implement measures that are going to streamline trial courts and result in cost-saving collaborations. So those rigid lines between trial court jurisdiction must be erased. And we have to implement more plans of concurrent jurisdiction where courts really share the workload in areas that they traditionally didn't have jurisdiction over. That way busier courts can be helped out by courts that really aren't quite as busy, and the workload can therefore be managed in a more efficient manner. Also, I think we need to consolidate courts. There are a number of courts and jurisdictions that just don't have the number of cases anymore, so we can consolidate courts down into one rather than 2 or 3 courts, also that will provide an ability to better use our resources. And finally, I think that judges, the number of judges that we need with our population diminishing has certainly decreased, and so we can start to limit the number of judges by attrition. So that is a major way that we can address budgetary constraint issues. Another issue that I think is primarily of concern is technology. Technology and case management go hand in hand. And I think this is one of our more critical functions, that we have to keep cases on track for speedy disposition. And we can certainly do that now by unifying and standardizing our technology and computer services. Typically, courts now just work with whatever they work with based upon the budget that they have in their local jurisdictions. And if we certainly move to standardize this, this will facilitate easier access to documents and even open and close case files, and it will help facilitate the use of concurrent jurisdiction and consolidated jurisdictions, because courts will have easy access to the information overall throughout the state. Also, I think we can use technology as well to help facilitate easy ways to pay when we have fines and costs, and for filing purposes. And that way, again, resources will be preserved because there will be less people necessary in order to process cases when we use technology. The third thing I think that's of importance is the indigent defense system. Historically, the resources available are not the same from county to county and from jurisdiction to jurisdiction. And so if we can standardize this, we will ensure easier access and equal access to justice for all people that are indigent. And so we would know that lawyers are equally trained, that they have equal resources when they need discovery and they need to hire services to prepare their cases, and we can certainly ensure that the resources for paying for their services are equalized, and therefore giving a better incentive for counsel to do their absolute best job. Well, one case that comes to mind that had a profound effect upon Michigan jurisprudence, in my view, is Trentadue versus Buckler. This is a case where the Supreme Court's ruling deprived a murder victim's family of their day in court by overturning precedent which had dated back to 1963, which allowed for the tolling of the statute of limitations, which was a 3-year statute of limitations for the cause of action for wrongful death. And this was a pretty heinous case because this involved a University of Michigan provost who was brutally raped, tortured, and then killed in her home in Flint, Michigan. And this happened back in 1986, and the crime really remained unsolved until 2002, when DNA evidence linked the perpetrator to the offense. And after the perpetrator was identified, the family wanted to bring a wrongful death case against him for money damages. And the Supreme Court really put the family in a catch-22 by denying the victim's family access to the court system by ruling that that 3-year window, which would have been the time to file suit, that started in 1986, would have ended in 1989 instead of tolling it until 2002. And so they were deprived access to the court even though they didn't know who to sue because that person's identity was unknown until 2002. So this ruling, in effect, rewarded wrongdoers and they were able to escape detection for a number of years and rewarded them with immunity from civil liability, no matter how guilty they were in a criminal court. Another case that I think had a profound effect upon Michigan jurisprudence is the case of Brown versus Brown. This case, the Supreme Court's ruling limited the rights of workers to sue for workplace sexual harassment. The court really ruled that an employer could not be held liable for the rape and harassment in a workplace. In this situation involved a woman in the workplace who had been repeatedly and systematically pretty much harassed by a coworker. And she had reported the harassment regularly to her employer. She had reported the taunts, she had reported her threats, and even the threat of rape. And then subsequently, she was in fact raped. And the Supreme Court basically ruled that an employer could not be held liable for any type of rape in the workplace or sexual harassment in the workplace, even if it's reported and the rape resulted, based upon a theory that there's no way that an employer could possibly know whether or not the perpetrator would carry through on the threats. Another case that comes to mind that really transposes scope of the landscape really of jurisprudence here in Michigan is Lugo versus Ameritech. And this case involved the judiciary, the Supreme Court, adopting an open and obvious standard. And this effectively repealed the concept of comparative negligence. So no matter how negligent you might have been versus how negligent the person or entity was and leaving the liability there, you still could have recovered in a comparative negligence situation. Well, now everything has been declared to be open and obvious by a reasonable standard, and this case Lugo effectively held that a pothole or a hole in a sidewalk was open and obvious and that no one could be seriously injured by falling into it. And this case law has now been extended to situations where even a blind person has slipped and fell and was injured, and it's been concluded that no matter if you're blind, that it's open and obvious and you have no right to recover for damages. One way to restore confidence that the judges' decisions are unbiased and fair would be to take the way we select judges out of the partisan system. The Supreme Court justices are selected by political parties, and this makes the decision-making process look too partisan. Because the Supreme Court is the final arbiter of what's fair and just and how the law is applied in the state, the current system only buttresses the concerns that the fabric of the law and the decisions of this high court can be affected by special interests that support the political parties who select the justices. And this is especially true in instances where, as with our current court, number of decisions seem to be systematically decided in favor of special interests, big businesses, insurance companies, over those of average citizens. So the partisan nature of selecting justices decreases public confidence in the judicial system and certainly in the integrity of the court's decisions. So I also believe that we should require recusal of judges where lawyers and parties have donated substantial amounts of money to political campaigns. A certain threshold amount should be implemented, and that way it really would ensure that there's no appearance of impropriety in the decisions of the court when the judge has to recuse themselves. Also, I believe that political action committees who may not donate directly, or maybe they do donate directly to a judge's campaign, but those donations should have more transparency in them. There should be possibly some changes in the law that would really make everything transparent so we know who's behind the ads, and so we know who has contributed to whom, and therefore the people can decide if they think that justice is being applied fairly and not just based upon political contributions, whether from PACs or individuals. Well, application of precedent provides stability and predictability in the evolution and application of the law, and it contributes to the actual and perceived integrity of our legal processes. The presumption in favor of upholding precedent may be rebutted if there is a special or compelling justification to do so. There are a number of evaluative criteria which may be relevant, but overturning precedent requires more than just a mere belief that the case was wrongly decided. So criteria that I would consider in determining whether to overrule precedent would be such as whether the rule has proven to be intolerable because it defies practical workability, or whether or not reliance on the rule is such as overturning it would cause a special hardship and an inequity, or whether or not upholding the rule is likely to result in serious detriment to the public interest. And further, whether or not the prior decision was an abrupt and largely unexplained departure from precedent without a constitutional justification or basis.